Get ready. Exercise number 47. Start. This writ petition has been filed by a group of daily wage laborers engaged in construction projects under the employment of a government contractor. Stop. The grievance raised is that despite working continuously for more than 8 hours a day, the wages paid to them are below the statutory minimum prescribed under the Minimum Wages Act 1948. Stop. The petitioners allege that the contractor, with tacit approval of certain officials, has deliberately surpassed wage records, manipulated attendance registers, and denied workers their lawful entitlements. Stop. It is contended that such exploitation violates not only statutory provisions but also Article 27 of the Constitution, which prohibits forced labor, and Article 21, which guarantees a life of dignity. Stop para. The state, in its reply, admits that the contractor was entrusted with execution of public works but claims that supervision of wage payment lies preliminary with the contractor. Stop. It is urged that occasional lapses cannot be attributed to the state and that sufficient mechanisms under the Act exist to redress grievances through labor inspectors and labor courts. Stop. The state further submits that the workers have alternate remedies available and that a writ petition is not maintainable in such contractual matters. Stop para. The court, after hearing both sides, observed that the Minimum Wages Act was enacted as a welfare legislation to prevent exploitation of labor. Stop. The object is to secure a decent standard of living and to ensure that no worker is compelled to accept wages below subsistence level. Stop. Section 14 of the Act mandates payment of minimum wages to employees engaged in scheduled employments, and any contract to the contractor oblique contrary is void. Stop. The Act imposes an obligation on both employer and principal employer to ensure compliance. Stop. Therefore, the state cannot escape possibility by shifting the burden entirely to contractors. Stop para. On facts, the court found that inspection reports indicated non-maintenance of wage registers and irregularities in payment. Stop. Affidavits filed by workers supported by testimonies revealed consistent underpayment. Stop. The court, under the denial of statutory wages, amounts to economic exploitation and violates fundamental rights. Stop. The plea of alternate remedy cannot defeat the enforcement of fundamental rights when wage sections of vulnerable workers are affected. Stop. Violence was placed on presidents including People's Union for Democratic Rights versus Union of India and Sanjeet Rai versus State of Rajasthan, wherein the Supreme Court held that non-payment of minimum wages constitutes forced labor under Article 27. Stop para. Accordingly, the court directed the state to ensure immediate payment of wage arrears to all affected workers within 6 months following which recovery provides shall be initiated against the contractor as arrears of land revenue. Stop. The contractor was blacklisted from future contracts for repeated violations stop. Directions were also issued to appoint independent monitoring officers to verify wage distribution oblique disbursement in all government projects stop. The petition was thus allowed with consequential reliefs, reaffirming that the wage to minimum wages is not a matter of charity but a binding legal and constitutional obligation ensuring dignity of labor stop. The state further submits that the laborers have alternate remedies available, that a writ petition is not maintainable in such contractual matters stop.